morning. We're here first today, only today, from our one case set for oral submission, Parker versus the State, AP 77-110. We'll hear first from counsel for the appellant. I'd ask each counsel as you approach the microphone to state your name and remind us of the party you represent so we can keep these recordings more easily for ourselves. Thank you.
Good morning, Your Honors, and may it please the Court. My name is Caitlin Halpern. I'm an attorney at Gibbs & Bruns. With me today is my colleague Connor Burwell, and together we represent Taylor Parker on direct appeal from her conviction for capital murder. Ms. Parker's trial was tainted by numerous errors detailed in our briefing, but we are here today to discuss just a few of them. Starting with issues 7 through 11 pertaining to the extraneous evidence admitted in the case, the Supreme Court in Andrews v. State recently warned that the exact types of extraneous evidence admitted here can amount to a violation of due process. There, Brenda Andrew was charged with capital murder based on allegations that she conspired to murder her estranged husband for his life insurance proceeds. The state elicited extensive testimony about her failings as a wife, a mother, and a woman, including testimony about her sexual partners, extramarital affairs, provocative outfits, and how often she had sex in a car. The state argued that this evidence was relevant to show a pattern of seducing men, culminating with her current boyfriend who had murdered her estranged husband. The state's strategy succeeded and Ms. Andrew was sentenced to death. But on habeas review, the Supreme Court found it had been clearly established for decades that introduction of evidence so unduly prejudicial that it renders the trial fundamentally unfair can violate due process. Quoting from a dissent in the direct appeal, the court noted, "An egregious pattern of introducing evidence that had no purpose other than to hammer home that Brenda Andrew is a bad wife, a bad mother, and a bad woman trivialized her life in the minds of the jurors." The Supreme Court then vacated and remanded for the 10th Circuit to consider whether the extraneous evidence so infected the trial with unfairness as to render the resulting conviction or sentence a denial of due process. The very same types of evidence were admitted here. Starting at the guilt phase and escalating at the punishment phase, the jury heard from witness after witness that Ms. Parker had weight loss surgery and that beforehand she had been very large. The jury heard that after the weight loss surgery, Ms. Parker was always flirting, showing off her body, and coming to work dressed like she was headed to the club. The jury heard about numerous extramarital affairs, including that at least on one occasion, her ex-husband caught her having sex in a car with another man.
Let me back you up for a second, if you don't mind. You were pointing out this evidence, your complaint goes not just to guilt, innocence, but also to punishment. What's your best case for the idea that extraneous offense evidence at punishment can give rise to a due process claim?
Our best case, Your Honor, is the case we've been discussing, Andrew v. State. The Supreme Court cited precedent going back to the 1970s, 80s, and 90s that this exact type of evidence can rise to the level of a due process violation.
But that's at punishment?
The court was considering both the guilt innocence phase and the punishment phase, looking at her conviction as well as her sentence.
But if we're looking at historical norms with respect to what evidence can be considered at trial, isn't it fair to say that, well, maybe let me ask it in the form of a question, isn't the punishment phase typically a much wider range of inquiry for the benefit of the jury?
It is a wider inquiry, but as this court has noted, there are still limits and still guardrails. So to give a couple of examples, the statute provides that evidence must be properly noticed. The statute also provides that evidence cannot pertain to the race of the defendant, and evidence going to gender and gender stereotypes is no less insidious than evidence going to race. This court's precedents have also noted that even at the punishment phase, the evidence must be relevant either to future dangerousness or to the sufficiency of mitigation. And evidence that, for example, her boyfriend thought she was overweight and gross and responded to her sexual messages with "I'll pass" had no relevance to either of those factors. So certainly there's a broader range of evidence admissible at the penalty phase, but contrary to the state's argument in their briefing, it's not without limits.
Can you remind me what the record shows were the steps taken by defense to preserve these arguments for appellate review?
Of course, Your Honor. So the first step was a written motion prior to trial where defense counsel argued that many of the acts alleged in the state's extraneous offense notices were legal and non-criminal, and instead were merely things that the state apparently considered inappropriate or transgressive. Then on the first day of trial, counsel renewed his objections both to notice and to substance, arguing specifically that the evidence was irrelevant and more prejudicial than probative.
Were they specific about which particular pieces of evidence? Or was it just sort of a generally, I don't want you to talk about things that my client has done?
The objections were general, but the court then granted a running objection, and this court has held previously that a running objection is sufficient to preserve an issue.
Well, I mean, if a trial judge says, well, I'll give you a running objection to your due process rights, what does that mean?
So it was more specific than that. It was a running objection to the admission of extraneous offense evidence that counsel had argued in the written motion prior to trial was irrelevant to any questions at issue in the guilt or punishment phase.
So the objection went to whether it was relevant or not.
Right, and that's the exact same objection that the court found sufficient in Andrew, that in Andrew, counsel had argued that the evidence at issue was irrelevant, more prejudicial than probative, and the courts nevertheless considered the constitutional dimension. And that's consistent with this court's precedents in cases like St. John, holding that arguing the substance of an issue is sufficient to preserve it, even if there's a new argument or new angle on it at appeal, and that's exactly what we have here. Turning back to what the jury heard at trial, we've talked about a lot of different evidence. A final example is that in jail, the defendant read over 100 books while awaiting her trial, including one that a normal person would consider sexually deviant. All of the evidence I've listed out today, and more that I don't have time to inventory, appealed only to the jury's prejudices and served no legitimate purpose. It was not relevant to whether she was dangerous or whether her mitigation case was sufficient, and certainly was not relevant to her guilt or innocence of the charged crime. Importantly, Ms. Parker had no criminal history and could not be cast as a career criminal. So instead, the state urged that she deserved to be put to death because she was a bad wife, a bad mother, once overweight, now promiscuous, in short, a bad woman. Again, as the Supreme Court warned in Andrew, this exact type of evidence can amount to a due process violation. And given the vehemence and extent of it, we have reached that threshold here. As to the guilt phase, this evidence was also a straightforward violation of Rule 404B. The state defended its admissions on grounds that it's contextual background, but this court has made clear in cases like Mays and Wyatt that contextual background is not a legitimate purpose. The purpose of Rule 404B is to ensure that a defendant is tried for the offense she has allegedly committed, not the type of person that she is. And that's why the state must satisfy a specific exception, such as identity or motive. But the evidence here, including the evidence we've discussed, as well as evidence about alleged lies about being heiress to a syrup fortune or fake pregnancies in prior relationships, were not relevant to any such purpose. Again, none of this evidence was admissible at the guilt phase because the purpose was only to show her propensity for lying to discredit her statements that Braxland was not born alive.
Why shouldn't we consider the admission of the evidence to be something that, while we might not have admitted all of the evidence that the trial court did, that the trial court might have had discretion nevertheless to make a determination in that gray area? Is your contention that none of it should be admitted, even though some of it might have had some marginal relevance? Because again, I mean, we're not talking about a standard here that's black or white. We're talking about, we have to show an appropriate level of deference to a trial court judge who's making decisions in the trial court with the parties in front of them. So how can you speak to that for a moment, please?
Of course, Your Honor. Prior to trial, the state actually proposed what I think would have been very reasonable. The state proposed that they wanted to go back 10 months and discuss this false pregnancy, the events with this romantic partner that led to this murder that Ms. Parker was on trial for. What we object to is that instead of staying within that 10-month limitation, the state went back 10 years to chronicle every alleged deed Ms. Parker had ever committed, and did that starting at the guilt phase. So we're not arguing that none of this evidence was admissible. There's far, far more than we cover in our briefing, but we're objecting to showing a pattern of similar conduct in prior relationships, events totally unrelated to this transaction and occurrence.
So do you make distinctions in your briefing? I mean, I've read it, but I can't remember whether it's, whether you make distinctions between those pieces of the evidence that you consider absolutely admissible versus those you consider, here's where the line should be drawn.
We agree that it's a gray area, and we don't think this court needs to
Well,
draw.
if you can't draw the line somewhere, how are we supposed to draw the line somewhere?
So two things, Your Honor. First, we would draw the line at that 10-month mark. We think for practical purposes of this
For the
case.
punishment?
I'm sorry, Your Honor.
Even for the punishment phase?
No, we agree that for punishment, it's a broader range, but wherever this court draws the line, the evidence here clearly went beyond it. And so one test is, can the state even articulate why this was a bad act? So all of the testimony about she was so fat, her stretch marks were gross, there's no articulable reason why that's even a bad act or
Are we
relevant to
limited
anything.
to the rationales that were put forward to the trial court as to why evidence is admissible?
You're not limited in that way, as this
So
court
if
has
there's any basis on which the trial court could have exercised its discretion, we're obliged to defer to that, are we not?
if that exercise of discretion was reasonable, but what the record shows here is the court never held a hearing on whether this evidence was admissible, didn't consider it act by act, just gave the state blanket permission to bring all of it in. So there's no reasoning and little decision making for the court to defer to. And again, those
If
core...
you put yourself in the trial judge's mind, what's the critical question before the jury? Not a punishment phase, but a guilt innocence.
The critical question before the jury, and I think this is a good pivot point, is whether there was sufficient evidence to show that Braxlin was born alive at the
Right.
time of the kidnapping or attempted
So
kidnapping.
couldn't the judge have been thinking that your client was very interested in having a live baby in her possession?
Yes, Your Honor.
And she left the scene with the baby, right?
She left the scene with the baby, which all
So
of...
wouldn't her mental state at the time she chose to leave with the baby be highly probative of that question? And perhaps her conduct and her behavior for a long time past would be reflective of that?
The state never defended any of this argument as relative
Yeah,
to...
but the answer you gave me a few minutes ago, remember, was if there was any rationale available to the judge to exercise that discretion, we would have to defer to that, right?
The court would defer on an abuse of discretion standard, to be sure. But I will be interested to see if the state can articulate any way that testimony about her weight and extramarital affairs and that she let her husband do the cooking and cleaning was relevant to her state of mind at the time of the
But to take you back to the
murder.
argument you've pivoted to, we don't have direct evidence of the respiration or non-respiration of the infant at the time she removed it, right?
The state failed to present any direct evidence, as was its burden, but
Well,
we have
because the
several...
state wasn't there, she was, right?
There's
So
sev-
why couldn't the jurors have inferred, given her apparent motive, if the infant had been dead, and apparently so, at the time she chose to leave, it would not serve her purpose?
There were several pieces of evidence introduced at the guilt phase that showed that the baby could not have been alive at the time of extraction. That included evidence from EMT Crosland and Trooper Shavers that her skin was discolored, indicating that she had been dead for some time. Testimony from Dr. Heron at the hospital that her...
But the person with the best knowledge of the state of the baby at that time would have been your client, right?
It is correct that my client was the only person who saw the baby at the time of extraction for
And
perhaps...
so her mental state at the time she chose to leave with the fetus is highly probative of the question of whether or not the baby was alive or dead at that point, right?
But again, Your Honor, the evidence that we've been highlighting today has absolutely no relevance to her state of mind. And to draw on a helpful example from this court has distinguished between transactional background and contextual background. And the example it gave was if someone commits a bank robbery, the court can allow the jury to hear evidence about procuring a weapon for the bank robbery, stealing a getaway car, casing the joint, but it cannot allow the jury to hear about prior bank robberies years earlier. That type of evidence is inadmissible and highly prejudicial
Or
because...
say smoking marijuana, right?
Exactly, Your Honor. Can't talk about other bad acts or unsavory acts unrelated to the crime at hand. It must be limited to the same transaction. And
I'm just
Go ahead, Your Honor.
thinking, my wheels are turning here.
wheels are turning.
Yep.
So going back to what the jury did hear about the life or non-life of baby Braxlin, the state itself presented 6 witnesses who testified that Braxlin never took a breath. 3 more witnesses testifying that she never had a pulse independent of medical interventions. That was evidence that came from the state. The defense didn't call a single witness at trial, didn't even cross-examine most of them, and so the jury had no basis to disregard all of that evidence to reach the conclusion that it did.
I'll hold you over for just a second, but the state did present evidence, I believe, from an EMT who was on the scene, who first encountered the baby, and based on the mucus and other material on the baby, indicated that this baby had been with her for quite some time at that point. Isn't that right?
That's correct, Your Honor, and that the skin was discolored, indicating that she had not just passed in the car, but had been deceased for some amount of time as well.
Is there any reason to believe that the child may have been deceased in the womb?
In the womb, yes, not, days before, but
What evidence suggests that?
so we have the evidence of skin discoloration.
But that wasn't until a long time after the extraction.
Right, there are 2 other pieces of evidence the jury had at the guilt phase, and then of course the evidence at the penalty phase. So at the guilt phase, the jury heard from Dr. Herron, the doctor from McCurtain Memorial Hospital, who testified that Braxlin's pupils were fixed and dilated, meaning she'd suffered permanent brain damage from a lack of oxygen, and that would have occurred in the womb. We also
Wait,
heard
who are you talking about, the mother or the child here?
the child.
The child had fixed and dilated eyes.
Yes, Your
But
Honor.
that happens when you die, right? I mean,
Dr. Herron
so the
testified.
kid was dead when the doctor was looking at the kid at that point?
Yes, so Dr. Herron testified that that would have showed a deprivation of oxygen.
Yeah.
Then we combine it with the testimony of investigator Cillian, a law enforcement investigator, who testified that the mother victim had lost so much blood that new wounds were not bleeding. That indicates that she was unable to supply oxygen and nutrients to Braxlin. That's the only time that the deprivation of oxygen could have occurred, because the 3rd piece of evidence the jury had at the guilt phase was an absence of any alternative cause of death. There were no visible injuries to the baby, nothing noticeably wrong with her. And so that's what really distinguishes this case from this court's prior decision in Craker, the sole case the state relies on. There, the baby had stab wounds, that was the cause of death. But here, there was no alternative to the fact that Braxlin passed before she was born.
And the mother had how many stab wounds?
Well over 100.
Right,
It was,
it's interesting to me because she was so careful not to stab the baby, right? So the mom got stabbed in a lot of places, but never where the baby was.
That's correct. And so then what we hear at the penalty phase from medical examiner Hastings is that a mother supports a child through blood flow that provides oxygen and nutrients. And when that attack occurred, when she experienced 100+ injuries, she was no longer able to supply oxygen to the baby, and that was the cause of death. That was corroborated by Dr. Hastings' hydrostatic test, which showed that the lungs did not float when put in water, therefore were not aerated, and proved definitively that Braxlin never took a breath.
Does this case require our court to decide as a matter of law when death occurs?
It does not, Your Honor.
Okay.
The only question is whether that death occurred before or after Braxlin was alive. And all of the evidence we've been discussing shows that the state did not meet its burden of proving that Braxlin was alive prior to her complete extraction from her mother.
Thank you, counsel. You have
Thank you, Your
a few minutes
Honor.
for rebuttal.
May it please the court. Counsel? My name is Jeff Shell. I am here as a special prosecutor on behalf of the Bowie County Criminal District Attorney's Office and its elected Criminal District Attorney, Jerry Rochelle. If there's one salient point I would like to make this morning, it is this: that a reasonable jury in Bowie County, Texas, could have found the essential element of born alive beyond a reasonable doubt. And that secondly, the trial court did not abuse its discretion in admitting the extraneous offenses during both the guilt-innocence phase as well as the punishment phase.
Well, counsel for the defense just told us that there was evidence admitted in the guilt-innocence phase of the trial, correct me if I'm wrong about that, her statement with regard to that,
Sure.
that the mother was fat. And what difference does that make in terms of establishing the elements required to show the crime?
Well, to be honest, it's contextual evidence. It is contextual evidence in the sense that it explains why this particular defendant, Taylor Parker, decides to begin at a certain weight. I'm fat.
Join the club.
And it explains why a person might go to weight loss programs, might go to other lengths to make oneself more attractive. I'm not sure I'm capable of that, but
I mean, I can see the connection between that here because she's trying to attract this guy
Yes.
to stay with her.
yes,
That's-
correct.
Okay, all right.
That's correct. And so, not to put this in my situation, but, you know, if there was someone that I was attracted to and maybe I wanted to be a partner with, maybe I would do some of those same things. But it all goes to what this particular defendant's state of mind truly was. And how we can't look at this case in a vacuum and say, oh, well, she was fat at this particular point in time in her life, and then she takes all these other steps to become attractive to someone else. That's all a contextual spectrum.
But does Rule 404B say contextual is a valid basis for admission of prior bad act evidence, or?
Not 404B does not say that specifically.
I didn't
but
think so, that's why I asked.
As 404B precedent has evolved, it certainly has taken on that aspect.
Okay, well, my recollection, it's been a while since I was in evidence in law school, but it's
Me too.
motive, intent, common scheme, things like that. But it's got to be probative to something other than the defendant's character, right?
Yes.
Okay.
It has to be apart from character.
And I understand the argument with respect to this could go to motive. Her motive was to retain this relationship. She was desperate because of the depth of her history, et cetera, et cetera.
Correct.
But the more you get into that, at some point, it becomes potentially cumulative, right?
At some point, yes.
And then there's a
it-
balancing to be done under Rule 403
Yes.
of the danger of unfair prejudice as compared to its probative value.
Correct.
And the more you have of it, now the weighing becomes more problematic, does it not?
Yes. Yes. But unfortunately, in this case, there simply wasn't an objection that was raised in the trial court that would have allowed the trial judge to perhaps gauge how much cumulative evidence there is. In other words, if there was a continuation of cumulative evidence that was extraneous, defense counsel could have very easily said, objection, Your Honor, this is becoming cumulative and therefore highly prejudicial under Rule 403. But that's simply not here. And as many of these objections that they are relying upon, it simply is not there in the record, and it's simply not preserved. And I think the state's brief in points 7 through 11 discusses that very fact.
What about this running objection? Is there a reason why we shouldn't consider the running objection to be sufficient?
Well, I think a running objection is what any reasonable lawyer does at the beginning of a trial. That's just to be expected.
You're not discounting the effectiveness of that in some situations.
No, I'm not. I'm not by any
Why is it
means.
effective here?
What is problematic here is that given this record is 59 volumes, it took an incredibly long period of time to try this case. Multiple pieces of evidence were introduced. It's a record that is unlike anything I've seen
Let me
in
put it
my
this way.
career.
So there's apparently testimony about the weight of the defendant in the case.
Okay.
So there's this running objection, though, that doesn't seem, maybe is a little bit non-specific, or let's just say less specific than would maybe be ideal, but nevertheless arguably had some specificity. Do you think that the specificity, if any, that it had, the running objection request, was sufficient to put the trial court on notice that the defendant would have complained about being called heavy, overweight? Or is that something that, is the trial judge going to be expected, based upon the objection, asking for a running objection, to say, oh, well, you can't say that because I gave you a running objection?
Right.
Are you following where I'm going with
Yes.
that? Speak to that if you could.
Sure. Okay. Here's how I'm going to address it. Reasonable, prudent counsel is going to ask for a running objection in any trial, whether it be this kind of a case, a financial case, a dope case, any criminal case that this court might hear in the future is going to encounter a running objection.
I follow that, but is there, the defendant, I don't think said, correct me if I'm wrong, but.
Sure.
I don't think the defendant said, I object to any inadmissible evidence. Was that the objection?
No.
Okay,
No, it wasn't.
all right. So,
And it wa-
any person would, if you could get away with that, what defense attorney wouldn't raise that as a running objection?
Well, but at the same time, a reasonably prudent attorney is going to object in addition to a running objection. You're going to be more specific with respect to what your objection is. If it's a weight issue, you want to say objection,
But I think that.
and then what that specific objection would be.
The rules of evidence, I think that the overriding concern of the rules is that you give the trial judge some notice of what it is that you want to actually complain about.
Yes.
So a general objection is not good enough.
I agree.
It has to be specific enough to give the judge some ability to understand that what's going on there violates what has been requested.
Correct.
And so, what was it? How was it stated? Was it stated in too general a terms?
It was stated in too general a terms. I think defense counsel looked at this and said, this running objection is going to cover me throughout.
And they
this
just stayed silent and didn't say anything when the fact remark comes.
Well, but if you look what the state did in this case in terms of pretrial notice, in terms of what the extraneous evidence is going to be, the clerk's record contains numerous references to what the state's extraneous evidence was going to be. And so to now come back and say, as defense counsel did, he says, I don't have a problem with the notice. I'm just trying to find out what you're going to rely on. But that's where he left it. And so when the complaint is about notice, and yet the notice is so very specific and so very detailed as to what the state intended to introduce as extraneous evidence, then I think it becomes an issue of the trial court needed to conduct a hearing of some kind to determine what parameters there should be. And defense counsel simply never got to that point. And so what is the trial judge in a case like this supposed to do?
Was running objection just to the detail of the notice, or was it also to the 404B and maybe 403 aspects?
I think when the court looks at the record, you'll see that it's limited solely to the notice. But again, if you look at this clerk's record, the notice is incredibly detailed and specific. It's not like the state produced a one-page document that said, this is our list of extraneous offenses, or this is our list of extraneous facts. It's multiple pages in the record to support this contention that the extraneous offenses were going to come in. The extraneous bad facts were going to come in. And it became incumbent upon defense counsel to object to those specific evidences.
Let me move you on from that, if you don't mind.
Sure.
I think
Moving
arguing
on
that
to a lighter
counsel
weight.
was ineffective at trial is probably not your best argument in a case like this. Would it have mattered if there was more detail given in the notice? If the timing had been different? I mean, putting aside the lack of specificity in the objection,
Okay.
you have other arguments that are relevant here.
Okay, the other arguments are that, well, first of all, as to notice, again, I think I've kind of covered
Yeah,
that.
I think you have. Yeah.
Okay. I'm making a point. That's good. The other aspect of all of this is the interaction of 404B with what the trial judge was having to deal with at the time of this case.
Because the defense counsel argued about the objection and the notice, but there seems to be you're either conflating or just mixing in the punishment phase with the guilt innocence phase. And I've yet to hear anything that bothers me about the punishment phase.
Okay.
And what they objected to, or if there was a problem with the notice, are you talking specifically about the extraneous acts introduced in the guilt innocence phase? And what you're trying to justify that?
Yes.
Okay.
Okay, and the reason why it's justifiable is it goes to the particular defendant's state of mind.
Okay.
That's what is the driving force in this entire trial. What would cause a defendant such as Taylor Parker to do all of these things, go from my weight to a slenderer weight to whatever she chose to do to make herself more attractive? See, all of this has a connection.
In the guilt innocence phase?
Yes, absolutely.
Well, let me clarify that, counsel.
Okay, sure.
Because I just want to make sure that applicant's counsel here made an argument about the comments about the woman being heavy, or fat, I think was the word. So let me ask about that. State's theory here, as I understand it, at least in part, was this woman did this horrible thing, cutting this child out, because she wanted to keep a man. Some version of that?
Yes.
Okay. And likewise, this woman was at one point fat and then became not fat because she wanted to keep a man.
Yes.
Okay. How are those two things not related? I mean, I understand you'd advocate that they are, but I understand counsel's concerns about the preservation, and I share them to some degree. But leaving that aside, I've heard defense counsel who will argue, hey, they shouldn't have said she was fat. Okay, but if she lost a considerable amount of weight to keep this man, and the state's theory is she did this heinous thing to keep this man, how is the trial court then out of his discretion to conclude evidence about losing weight and these other things she did for the same motive somehow inadmissible?
It's not. It is admissible. It's admissible because it again, cases can't be tried in a vacuum. And this case began with references to being fat, overweight, however you want to characterize it. But then it also explains how she went through other stages, I'm just going to call it stages of her life, to become something different. And then in order to keep this man, as you say, she performs the crudest form of a C-section
Let
to
me ask
take
you
a
that.
baby, a fetal abduction.
A question about that, back to what Judge was saying earlier.
Yes,
She started with a knife,
yes, it didn't work.
but then she moved to a scalpel, which she retrieved from her car from a kit she had prepared.
Yes,
Okay, and I understand there's some testimony about prepared for animals, but as it relates to the issue of whether the jury had sufficient evidence to conclude that this child was born alive,
yes,
if she was doing what she was doing with a knife,
yes,
and she concluded what she was doing with the knife was not sufficient to her end, and she retrieved a scalpel,
yes,
could not the jury then conclude that her end was to obtain and leave with a live child?
absolutely.
What other reason would there be to stop with the knife and retrieve a scalpel?
She clearly was calculated in her manner and means of extracting baby Braxton.
Alive.
alive. And the direct evidence that you have may not be there. But direct evidence is just as probative as circumstantial evidence. And the circumstantial evidence was certainly sufficient under a Jackson v. Virginia standard of legal sufficiency.
Well, you're talking about whether the baby ever was born and breathing, right?
Yes.
But you do have some direct evidence, do you not? You've got the helicopter paramedic who testified, I believe, that there was respiration on the
Yes.
on the
Yes.
life flight.
And if you read the EMT, his name was Cortland, if you read his testimony, he explains how when he found the baby, when they get dispatched from DeKalb, Texas, and they arrive on the scene, it's about a 12 to 13 minute window. And when he gets there, he sees a baby that is ashen, not pink, and not crying. He sees amniotic fluid that is dried. And he begins the process of resuscitating that child. And if you read the testimony, at the end of the day, when they get from the place of the traffic stop to the McCutcheon County Memorial Hospital in Idabel, Oklahoma, he's ecstatic because he's gotten a pulse. And he's resuscitated baby Braxton. And he describes this as when they leave the hospital, he's ecstatic because he's brought a child back to life.
He got a pulse. Did he get a breath?
He got a pulse, and then they start the compressions when they get to the hospital. When he's able to get a breath and a pulse.
How do you respond to the point about the lungs that wouldn't float?
Well, I think that is some evidence of perhaps of an opposite fact. But to Judge Urie's question, is this one of those kind of cases where you have to decide when does life begin and when does it end? In this context and in this specific case, I don't think the court needs to answer that question because
Well, let's not say the court has to answer. Let's go back to the record. I mean, does the testimony from that expert indicate how many breaths it would take before a lung would float?
I don't believe so.
Okay.
I don't think the record establishes that.
I mean, one would think that,
Well, what if it
Even-
does? What if he said it's only one? Only one breath would be required and then they would float and these didn't float. Does that sink your case?
I don't think so. No. Because if you look at all of the evidence, and this is what the Jackson standard of legal sufficiency requires. The combined and cumulative force of all of the evidence must be considered. And so when you consider the jailhouse informant and her testimony, I know, I get you. I'm not one to lead with that, but there you go.
No, I
That's
mean,
the direct evidence.
Even if you take it at face value, that didn't prove anything.
Well,
What did that prove?
But it corroborates that this defendant told this jailhouse informant the baby was alive.
No, that's not what the statement was.
I think that, the record, we've set forth in our brief what she says, what the jailhouse informant says.
Say
But
goodbye to mama.
say goodbye to mama. The baby was alive when she took it. That combined with the EMT's testimony that they get the baby back, I'm going to call it get the baby back, they get a pulse, they get to McCutcheon Memorial Hospital, and the EMTs have thought they've saved the day. When you combine that with the doctor's testimony that this baby was viable, she was 7 pounds, 18.75 inches long. There were no cuts on the baby.
Well, viable doesn't mean alive at the time of birth. It means potentiality for that.
Let me leave the court with this. Page 13 of our brief sets forth Dr. Heron's testimony that the infant was viable. Question, and I'm going to quote, I know I'm over my time. May I proceed?
I gave her some extra, go ahead.
Okay, all right. If that baby had been dead that entire time, do you believe they would have gotten a pulse back? Dr. Heron's answer is no. Logic tells you that the baby was alive. This is a 36 volume of the reporter's record, pages 39 and 40. That's the direct evidence. The doctor says if they had gotten a pulse back, the baby would have been born alive. Logic tells us that. The medical testimony proves it. Reasonable jurors that are parents like myself would make the same determination.
I still have one more question, I'm sorry. Everybody let me, it's very specific though. I think I read something in the appellant's brief that it said something like, in order to be alive, you have to have breath and pulse, right? Both of those things. And I looked at the citation that they pointed me to after that, and it said, I think 20.015, and you have to be born and alive. But that doesn't really answer that question that was presented by the sentence that preceded it, which is, do you have to have both a breath and a pulse before you can be considered alive? And my question is there any specific statute that exists that tells us what is necessary to be considered alive? And if not, is it something that is completely within the jury's ability to discern? I mean, is it just what a normal person would think?
The answer to your question is no.
No specific statute?
No specific statute. That is correct.
And yes, apparently.
And what?
And yes to the jury, it's up to the jury.
And yes to the jury's determination as to what they want to find.
And but before I let you go, I got one last question. You've got already, at the time you started offering this extraneous evidence,
Yes.
unquestionable proof that you've got her at the side of the road with an infant or a baby that's not hers,
Yes.
a corpse a mile away that she has removed the baby from.
Yes.
What is the incremental probative value of this other extraneous evidence to go to motive at that point?
It begs the question, why did she do it? What is her mental state to allow someone to do something as heinous as this? That's what it does. If the court has no other questions, this guy that needs to lose weight is going to sit down. Thank you.
Counsel,
Yes, Your Honor.
before you start, I need to ask you a question.
Of course.
Do you agree that the facts in this case are particularly horrendous?
Yes, Your Honor.
And what your client did was a terribly horrendous act. You agree with that?
Of course, Your Honor. We're not challenging that today.
Okay. And if the state hadn't have messed up and asked too many questions about things that were inadmissible, don't you agree that the jury still would have found your client guilty?
Guilty of murder, but not guilty of capital murder. The difference there is a difficult technical question that Your Honors have been grappling with all morning. And the problem in this case was the jury was distracted from that difficult, discrete inquiry by the circus atmosphere of all of this extraneous evidence. So turning specifically to the thin reed the state relies on, I'd like to address Dr. Heron and EMT Crosland. The problem with Dr. Heron's testimony about getting life back is he admits on cross-examination that's just an assumption or a guess or speculation. And not only that, but specifically, it's an assumption that, well, LifeNet wouldn't have done all that they did if the baby hadn't been alive when LifeNet arrived. But Dr. Heron acknowledged on cross that he had not been told that the baby had no breath and no pulse at the time the EMTs arrived. So as a result, that testimony is not merely a conceded assumption, but an entirely unreliable one at that.
But isn't that something for the jury to consider and decide who they believe?
In a sense, Your Honor, but more than that, the precedents of this court and the Supreme Court have held that the jury's verdict must rest on facts. It cannot just be guesswork or assumptions. There must be reliable facts to support the jury's verdict. And
So is your position there are no reliable facts based on this list of things that the state has just mentioned as far as supporting the sufficiency of the evidence?
our position is that the state did not carry its heavy burden of proving guilt beyond a reasonable doubt, that the reeds are too thin and far insufficient to prove guilt beyond a reasonable doubt, certainly not overwhelming evidence that would render all of the other errors harmless. Specifically as to EMT Crosland, his testimony was that when he arrived on the scene, Braxland was obviously dead. He testified about the skin discoloration, the absence of any signs of life. So even if this court adopts a different definition of born alive, there wasn't sufficient evidence as to any alternative sign of life. Not breath, not pulse, not movement, not brain activity, not response to pain. There was nothing sufficient for the jury to rely on here.
What about what she said to the jailhouse informant? Are you discounting that totally?
The jury was certainly entitled to consider it, but it was insufficient for several reasons. First, the statute requires that it be corroborated, and it was not. Second, the state...
Was there an objection to that?
Not at trial, Your Honor, no. But the second problem that should have been clear to the jury was that the state itself elicited testimony to discredit the jailhouse informant's account. The state elicited that Ms. Parker had lied to the jailhouse informant, including by saying that she pulled over when she realized the baby was in distress, instead of the truth that she had been pulled over by Trooper Shavers.
Again, isn't that an issue for the jury to decide as to the credibility of that witness when they hear this contradictory testimony?
Our position is that when the state itself at trial discredited certain testimony, that testimony is then insufficient for the jury to rely on.
All of it?
The jailhouse informant's testimony, yes, the jury could certainly consider it, but the statute requires corroboration, and under the legal sufficiency test, where everything is considered, yes, in the light most favorable to the verdict, but ultimately to decide if there are sufficient facts and not just assumptions that the jury could rely on.
My question earlier.
Yes, Your Honor.
Given your client's apparent motive, her conscious decision to leave the scene with the baby, why couldn't the jurors reasonably infer that she had determined for herself that the baby was alive at that point to make that decision?
There was no reason for the jury to infer that the baby was alive simply because Ms. Parker took the baby with her.
Well, would that be against what we would call her penological interest to be carrying a dead baby with her in a car when she could have left it at the scene if it was already dead?
The state's entire theory at trial was that Ms. Parker's goal was to pass the baby off as her own, whether alive or dead. So regardless, she needed to take that baby with her. And if the panel has no further questions, thank you so much for your time this morning.
I want to thank both counsel for excellent work on this case. We appreciate it very much. We'll take this case under submission, and the court will stand in recess until such time as we don't.